Supplementary list for delivery of judgment, item 28.
The impugned eligibility framework represents a legitimate exercise of contractual discretion aimed at safeguarding public interest in a technically sensitive project. The appellant has failed to demonstrate that the conditions are vague or unworkable, or that the process is arbitrary or unfair. For the aforenoted reasons, this writ appeal is dismissed and the impugned judgment passed by the 11th single judge is sustained and upheld. I agree.
Adjournment request, if any, from item number 1 to 6. From item number 7 to 18.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 4.
Number 4.
My senior legal aid counsel is out of station.
First time, no? Delay of 260 days. We'll be issuing notice. Don't worry. Your senior is not required here. All right. Wait for the case to be called out. You will understand. You are very new, it appears.
My senior counsel is the legal
Doesn't
aid.
matter. You understand my language, no? Wait, let the case be called out. We'll pass an order.
Please, Lordship, I beg to mention item number 8.
Yes, you have
For
certainly.
examination.
All right. Give the date.
1st June. From item number 19 to 27. Sorry, may I please, Lordship? Item 13, my lord. Affidavit in opposition filed by the officials. 13. It's
What do
filed.
you want?
I have to file, didn't reply, my lord, but 2 weeks maybe.
You have to file reply.
Reply.
You're for the respondent.
I'm for the petitioners.
You want to file a rejoinder.
Agenda.
Yes, Mr.
Take it, Taluda.
Mr. A.K. Talukdar led an advocate for the petitioner. Seek some time to file a rejoinder petition. Rejoinder affidavit. Let's say the rejoinder affidavit be filed on or before the next day, 6 weeks.
5th June, 5-6.
May I please, Lordship?
Yes,
Lordship, in item number 22, for the respondent, Lord, I am required to file an affidavit in the matter. Lord, I pay for 3 weeks' time in the case. I have informed the other side.
can we say as jointly prayed for?
No.
Can we say as jointly prayed for?
I have
No.
I have taken
No.
taken the consent.
The prayer for adjournment has been made by Mr. D. Nath, who appears for respondent number 9.
Wonderful. For the state respondent, PWD.
For the state response.
Respondent.
Let this matter come up for consideration on your date in July.
15 July.
Complete the work by that time.
Lordship.
And how about the money, 1 crore, which has been siphoned off by the contractor?
No, that is that in the affidavit we have already said
All-
that was not paid.
All right, so in July,
Madam,
before you come to us,
15 July.
get the information that the work is over.
Lordship.
All right.
May it please your lordship. As regards item number 14, my lord, we have filed one affidavit, my lord. So that may kindly be called for, my lord.
Item number 14.
14, my lord. On behalf of Assam State Legal Services Authority, we have filed an affidavit.
Yes, Vishal.
Lordship's please, item number 29 and 31 of the supplementary list, my lord.
Yes.
I'm shifting a short accommodation today, my lord. The services and all are complete, my lord. I'm just requesting for 2 weeks or 3 weeks time to be granted, my lord.
29 to 31.
29 to 31, my lord.
So otherwise also it will come. Mr. R.B. Booker, learned advocate, submits that in all these matters, the service is complete. In that view, in view of such submission, let all these writ appeals be listed under the appropriate heading on
Any day, my lord. Any day, June.
24th June.
Can it be, my lord, slightly early if it is not inconvenience? Any
First
day,
week of June.
first week of June, my lord. Extremely good.
all right.
First week of June.
10th June.
8.
10th.
May it please to your lordship, I beg to mention item number 23. We have submitted adjournment slip. Kindly meet me.
All right.
26th June. Any other request?
May I please, I beg to mention for listing one IA, my lord,
I have
for condonation of delay, my lord, 31 days.
tomorrow.
May I please? Also, I beg to mention for listing one repeat for tomorrow. What happened in this case, the petitioner is a cancer patient, man of brain cancer, and he was transferred in terms of the guidelines of the election commission, my lord. And there is a provision, if there is any hardship, they can approach the chief executive officer.
Did you approach?
Yes, my lord, I have approached.
Then what happened?
No action has been taken, my lord.
So you have to give a reminder. And what did the single judge say?
My lord, by this time, if he is released, my lord,
By what does the single judge say?
single judge said, my lord, once it is in terms of the guidelines of the election commission, there is no relaxation.
No, but you said that there is a relaxation if there is a difficulty. Which part of the rules or
Rule 5 of the election.
Day after tomorrow.
Day after tomorrow, my lord, it's holiday, my
Day after tomorrow is a holiday.
lordship.
So it has to come. Otherwise, it can't go to Monday. Monday.
Monday, my
Tomorrow there are many matters.
lordship.
Monday.
All right.
Daily list for this item 1.
In this case, I may be allowed to take fresh steps to solve this number 1 and 4.
It appears that for a long time, the response number 1 and 4 have not been served. It appears that there is some mistake in the applicant, having stated their address, their respective address. Let fresh steps be issued to response number 1 and 4 on steps being taken by the applicant, with it including furnishing of their correct and present address. Requisites 2 weeks, both modes returnable to life.
13th July. Item 2.
No step taken. Yes.
Please, your worship, we have taken steps as per the last order 6/3/26 upon respondents. Service has not been completed. Await service report.
You're reading out Lavazima order or some order. Have you taken steps for service of notice?
Service has not been completed.
आपने steps ही नहीं लिया है. Steps for service of notice. It appears that no steps have been taken for service of notice on response number 1 and 2. Let requisite steps be taken by the petitioner within a period of 2 weeks, failing which this application shall be dismissed without further reference to debate. What will you communicate to your senior? क्या बोलेंगी उन्हें जाके?
That service has not been taken.
हाँ, तो हमने ऑर्डर किया है कि आपने स्टेप्स नहीं लिया है. If you don't take steps for service of notice, you have to file requisites in the registry. Some money has to be paid. If you don't do that within 2 weeks, this application will be dismissed without reference to the bench. Registry dismiss कर देगी. That you must inform your senior. You're not understanding, huh?
13 July. Item 3.
What contempt of which order, where?
Lordship, in fact, your lordship, that's your lordship undertaken given by the authority.
Given by which authority?
Your lordship of the state authority, your lordship will kindly come to page,
Where, before which body?
lordship will kindly come to page 139. Para 3. We are essentially, your lordship,
Read
or
the
not,
order.
but lordship, learn the decisional because general of some appealing for the respondent state has submitted, the state government has decided to implement the recommendations of the remedial measures suggested by the one-man inquiry commission for the purpose of checking the illegal mining activities in the concern. Whether state government had notification number so and so has declared this so and so is from the forest then it is submitted to the same state page manner as remedial measures to check illegal coal mining activity. Now, this is a solemn undertaking given by the state authorities before this honorable court. And now, your lordship, our case is that, and in fact, your lordship has already directed the other digging patkai matters, your lordship.
Mr. S. Board Thakur led an advocate for the petitioner submits that notwithstanding the clear undertaking given by the government learned additional advocate general of Assam in PIN 3 of 2022 that the recommendations and remedial measures suggested by the one-man inquiry commission for the purposes of checking illegal mining activities in the concerned area shall be implemented. Nothing has been done in that regard. This is a clear violation. This is a clear breach of the undertaking and a violation of the court's order. Let notice be issued. Let notice be issued to the respondent state, respondent/answering authority. Mr. Swami Ladad, additional advocate general, accepts notice. Accepts notice. And submits that he shall be responding to the present application by the next date, re-notify on. We are giving you 4 weeks. 4 weeks or 6 weeks?
Deeply obliged.
24 June. Item 4.
Accept notice? You want to object?
Hello?
You want to object? You'll file affidavit or should we condone?
Hello? 260, madam. I'll file affidavit.
Affidavit shall be filed by Ms. Gyan.
Must have.
4 weeks, 6 weeks.
Must have.
No, 4 weeks.
Yes, sir.
You file your affidavit.
Yes.
19 June.
You wanted time in this. You wanted time in this, no?
Yeah.
So we have already issued no.
Item 5.
Lordship, I kindly take up my IA. Malad. The
What is it?
IA Malad 52 of 26. Well, in the cost title of the writ appeal, but some respondents, vital respondents, they were late now. So we have sought for amendment.
What
of
is this matter?
This is an appeal Malad, against the order passed by the single judge by which the 2 petitioners were directed to reinstatement along with back wages.
The police personnel.
Police constables.
Ulfa
one-
connection.
Yes, Malad. Number 2, respondent number 2 is the probationer. He was a probationer and the
No,
petitioner.
you want adjournment, why?
No, I pray for taking up my IA. Interlocutory application is there, IA 52 of 26. Yes, Malad. Lordship.
Why only I?
Now,
Just-
I IA is for amendment of the cause title because some of the officers, they were not inadvertently left out in the area of the party.
No, but these two only had preferred writ petition, no?
True.
Then
No, now the officer under whom they were serving, the SP Golaghar and the commander.
it's essential. We are looking at the just, I mean, we can always repeat any one of them.
No.
But then whether it is essential, we'll look at it from the point of view of the law which has been enunciated with respect to parallel inquiries or domestic inquiry or the opinion in one to be weighed in another. That's all.
One difficulty I am facing, Lordship, there is an order that I must file an application for condonation of delay because some delay has been pointed out.
Because some delay had been
Yes,
followed up.
yes.
Did you file an application?
No, that application, the difficulty is the concerned officers inadvertently they were not their party in the appeal.
I
Therefore,
don't understand this. Mr. Nath, why this insistence on change in the cause title, permission for change in the court's title? Why?
in the
I
appellate,
mean, we can do it, but I don't think for a writ appeal to be maintainable, you need to implead persons who have deposed against them, or for that
No.
matter, they were seniors to them. I don't know.
no, what I am saying, the condonation application has to be filed with the SP, but SP inadvertently he is not a party. Therefore, the SP has to be arrayed.
Can that be a ground, Mr. Nath? You have been in practice for so long, such a seasoned counsel. You file who has filed, the appeal has been filed by whom?
By the commissioner.
So you will file an application for condonation of delay.
Not.
I mean, you unnecessarily you complicate. This is a problem which I find here. This jurisdiction, I'm sorry to say, always, you create a ghost and then make an attempt to kill it. Why? Have we questioned it?
But
Have we questioned it?
Well,
You filed an appeal.
in fact, there is a
You should have filed an application for condonation of delay, which we would have had for the reason that the delay would not be, it would be reasonable time. I don't think this is an old judgment.
no.
You
There is
have
not
done that unnecessarily. You have come for changing the course title, impleading the SP. Who is SP in this matter?
They are the disciplinary authority, my lord. The disciplinary authority of the respondents, my lord. The repetitioners.
You are.
But I got that. I got that. Well, I got that.
What do you want?
But my IA is pending. That is
I
what
think your IA is for stay of the operation of the judgment. I perhaps thought that.
But
Now, this is what I say. That should have been your first endeavor rather than asking for impeachment. Anyway, I'm not understanding what you are saying. Maybe I have a different way of looking at it. You filed an appeal, you file an application for condonation of
some technically,
no
difficulty.
technicalities here.
Lordship, I take it. I take
I
it.
think you have understood.
Yes, my lord. I take it.
It did not even occur to me that you will be filing this application for this. I think this application, therefore we said that we will decide the application.
Yes, Malad.
We will decide the appeal
Malad.
straight away.
Malad.
Because I thought that you are asking for interim stay and then final hearing.
No, but
That is not done.
otherwise, my lord,
Whether it is dismissal or reinstatement, there is no interim order. You know that.
Lordship.
Either it has to be decided, rejected or allowed.
Yes, my lord. Lordship. With the appeal,
When do you want it?
I'm ready with the appeal. Otherwise,
So, are you with me?
Lordship.
Oh, sure. The application has to be filed.
That has to be fine. That has to be fine. Kindly.
You file the application,
Malad.
Mr. What is his name?
Malad.
Mr. Gorpat Goy will raise a serious objection which he raised last time.
Well, before the vacation, by when
File your application by tomorrow.
Yes,
Day after tomorrow.
by
We say that.
Malad.
And then it shall be heard because
Lordship
the
may-
democracy, has he been reinstated?
No.
So, without the stay, without the application being processed, without the appeal even coming for admission, you had to do that.
But the appeal came up for admission, and Lordship, it came up
Mr.
for
Nath.
admission. On Monday, kindly take up. I'll file the application by the time.
The learned senior government advocate submits that necessary application seeking condonation or delay in preferring the appeal shall be filed by the next stage. Stop. If that application is filed, let it be listed along with this WA. I think this is the way when you can avoid the delay.
Lordship.
Along this, either the judgment has to be upheld or has to be set aside.
Yes,
We
yes.
can't keep him pending, hanging fire like this, the issue.
True.
Correct? And anyway, application shows the next step. Process we should shall file condemnation application by the next date. Stop. Let that be done on or before the next date. Shall be filed within a period of 1 week. Stop. As and when such an application is filed, let such application be listed. Preferably, second week the last. 1 week is going to file, second week the last.
No, on the floor. 23rd April.
Prepare
23rd.
merits, Mr.
I'm yes,
Please, have it read. Please try and explain to us. Now, how do we explain? The suitability aspect is very important. The evidence also is same, everything same.
Mal.
But whether it will, and what is honorable acquittal? These words are not there in the Code of Criminal Procedure. So it has to be explained.
Malu,
Please be ready on that. And then Avtar Singh of 2016. What is expected of a police officer?
We'll do it.
Oh. All right. This is just to guide you that you must come prepared on the issue of law, not only on facts.
No,
On the next day, so that it doesn't come as a cell shock to you.
no, we don't.
All right.
It was because of my eye problem, because I'm under medical treatment. That's why today also I've come.
No, today he must cross that threshold, no? Unless his appeal is ready to be processed and listed, nothing can be done.
Malu, next time I'll be coming prepared and I'll just satisfy
We
you.
don't know.
Awesome.
All right, next day.
Item 6.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, learned senior counsel Mr. Ken Sugri will appear. So, Your Lordship, kindly pass over the matter for time. He is on leg.
Mentioned that in the beginning. For the time being, no, we don't. But the roster is set.
In that case, Your Lordship, kindly fix that to Your Lordship, if it is possible.
It goes on another. A prayer for Passover has been made by the learned counsel for the petitioner on account of unavailability of Mr. Ken Chaudhary, learned senior advocate, who is to address this matter. Seeing the board today, it is not possible to accede to such a request. Let this PIL be listed on. We can give you sometimes in May or in April if it is urgent.
Then, Your Lordship, immediately after vacation. Hi, Your Lordship.
7 April. Item 7.
One second. Yes, Mr. Roy.
My lord,
Yes, Mr.
my lord, I find my lord secretary has gone more on sympathy because the petitioner, original petitioner died.
Take your case first. Yes,
My lord, the petitioner challenging an order passed 7 years back after retirement has approached this court, my lord.
Is that important? Now he challenges it after 7 years when he challenged the other proceeding.
Yes.
Where there was recovery.
Yes.
Still in 7.
So,
Therefore, this makes it very stark. That's your argument.
the last,
That should be
exactly,
your argument.
exactly.
Yes, sir.
My lord, if your lordship look at what sort of disciplinary proceeding it is. I will take
No,
your
but
lordship to,
But did he not accept it? Because suppose he would not have challenged both the proceedings.
that cause of action was different, my lord.
Maybe different, but he knew he won that case.
No, but the
But then you wait for you to retire and then file a case, something which was initiated in 2003.
No.
It ended in 2005. You file it in 2012, and then your wife is pursuing it because sympathy is with you.
No, just for a moment, my lord, if I take your lordship to page 115,
For what?
my lord, the evidence given, is it an evidence, my lord, in a discipline
It's
proceeding?
different. But then you chose to accept it, no?
No, that was not accepted, my lord. That earlier cause of action is totally different, my lord. I will take your lordship to that.
Anyway,
also.
let us see your page.
My lord,
I mean, we are not able to cross that stage when we see the merits. We are probably finding the order passed by the elected single judge condoning the delay of 7 years in this background, in this fact scenario, to be absolutely difficult to digest. Now, merits, of course, we will see, but on this score only, we are likely to admit this and perhaps dispose it of today, setting aside that order. I mean, we have told you, you can address us on that ground.
my lord,
We
in
don't
that
get
case-
into the merits of the case first.
In that case, my lord, if my learned friend is ready with the record, that will be better, my lord. Because of what
He is
way,
ready with the record. He is ready. You argue, he will respond. Mr. Roy, you are ready?
I can write.
You are ready or not, Mr. Datta? Please tell me.
Kindly, I will take your lordship to my lord, page 115, the evidence given in this case. Now, whether, my lord, it will persuade you. lordship.
Before that, we would plead you, we would urge you to satisfy us on this count. Now, it may be without any substance.
Precisely on what, my lord?
On the ground of delay, and delay not just like that, it was not just one proceeding.
Correct, correct.
The other proceeding was concluded against you within 12 days of the first proceeding, correct? And you challenged that. You challenged the recovery of 1,96,000 or something.
My lord, on that.
Plus,
part,
you are censored also.
Yes. Those
So
are the-
if you would challenge it there and then, why did you, Mr. Chaudhary? This is standing in the middle. Mr. Chaudhary. Mr. Chaudhary. A Passover was made on your town.
Yes,
We cannot do it in the board today. We have kept it after the.
there was some urgency, my lord, because without getting any forest clearance, they are going ahead with the tender. Well, I'll satisfy your lordship, my lord. There are two forest divisions. They have taken clearance from only one forest division.
That's all right, but immediately after the obligation.
But even then, my lord, they will process the
No,
tender.
what they will do it this is the time when all of them.
No, my lord.
This is
My lord, the Wildlife Authority of India, they gave a suggestion that they should change the alignment, in which case felling of trees can be avoided. Which has
We will hear you on some other date. What date, Karno? Not possible.
if at 2 o'clock today, my lord.
Really not. Today we have fixed many matters. We can do it next week.
On 6th, my lord.
6th, again, you have many matters. 6th, 7th, you have many matters. Keep it on 10th. 10, 9, 10, 8. 8. उसको date change कर दो. Yes. Yes, Mr.
My lord, in that case, your lordship, I will address your lordship to those facts, my lord, on some other date.
Because
After
we
this.
must have, you must pave the way for us to enter into merits. At this threshold, we are finding it to be difficult.
No, my lord, I will totally persuade your lordship to that date also.
We'll just give our introductory note
Yes.
so that you prepare it. The Food Corporation of India and others / appellants have challenged the judgment of a learned single judge dated 25/2025, passed in WPC number 4379 of 2012, directing the sole respondent to be given notional, setting aside the punishment imposed upon the respondent who is not in the world of living today, and to accord him notional monetary benefits which shall be received by his heirs, and in this case, particularly the wife of the deceased employee. Now, in the year 1997-98, serious irregularities were discovered at the coal storage depot of the FCI in Dibrugarh. The depot was manned by the employee / late Bhuvan Chandra Basumatari as the in charge of that depot. It was found in the inquiry that in just 1 year, there was an abnormally high storage loss of food grains to the extent of 15% in 1 month against the permissible limit of 0.5%. The investigations revealed many irregularities, including mismatch in the stock ledgers and the number of gunny bags which were used for lifting particular quantity of food grains. The appellant FCI had initiated a departmental inquiry against the aforenoted employee in the year 2003. In the aforenoted domestic inquiry, charges were proved, and the employee was visited with the penalty of reversion to the lower post, with pay fixed at the minimum of that scale till retirement. Close to the heels of the aforenoted domestic proceeding, another departmental inquiry was initiated against the employee, where also he was visited with punishment of censure and recovery of rupees 1,96,875. So the employee chose to question the correctness of the conclusion of the second inquiry and was successful in that attempt. The order passed by the disciplinary authority was set aside. So all this while, there was no challenge by the employee against the punishment imposed on him in the first inquiry of reversion to the lower post till his retirement. He remained in service for about 7 years and demoted his office sometimes in 2012. It was only after his retirement that he preferred a writ petition before this court by WPC number 4379 of 2012, questioning the 2005 reversion order. During the pendency of that petition, unfortunately, the employee died on 8/10/2016, And the appeal was pursued by his wife and children, who later substituted in place of the employee. It was in this context that Mr. Roy, learned advocate for the appellant FCI, submits that the order, that the learned single judge was actuated more by sympathy than by the merits of the case in setting aside that punishment and directing for giving notional monetary benefits to the family of it. Mr. Dattal and senior advocate, Mr. Sishir Dattal, SISIR or SH?
SISHIR.
Sishir.
Yes.
Sishir is winter.
Yeah.
Mr. Sishir Dattal and
Few drops rather.
Mr. Sishir Dattal and senior advocate appearing for the respondent submits that he shall argue on the aforementioned aspect on the next date. Re-notify on whichever date.
Can it be on 23rd April?
27th of April. Or you can have a date in May also. Have it in May.
Yes.
22nd of May. Or 26th of May, whichever.
Yes, your lordship, please.
26th of May.
Not so. Right.
Item number 9.
They are the caveat in this.
Yes,
My lord,
you are the supplier.
my lord.
You are the supplier.
Yes, my lord. I am the supplier.
We are not in agreement with the letter single judge's order.
No, my lord.
The
yes.
machine has not worked even for a day.
No, my lord. My lord is correct. The machine is not working. That is a disputed question of fact. The line of single is a very
What is a
clearly
disputed
key-
question of fact? And on a disputed question
No,
of
my
fact, the
lord.
single judge ought not to have asked for release of payments.
No, my lord. That
We are staying that order straight away.
with all due respect, my lord, with all due respect, my lord, there is a my lord guideline under which my lord, by which the contracts are governed. And my lord, my lord, the general, my lord, that the
All
GEM,
these
that
grounds,
marketplace,
all these grounds
no, my lord, the guidelines and the
would
notification,
not appeal to us, sorry.
my lord,
The
very
machine has not
specifically,
worked for all this while. Patients are being diverted to other centers. The cost is to be borne by the state. And then one machine you supplied and you did not even correct it.
no, my lord, I'm only the supplier. My lord is correct. I'm only the supplier and the manufacturer is the PPL.
Not at all. The order shall remain in abeyance. First you satisfy,
lord.
repair the
No, my lord, only,
machine,
my
make it
only,
workable. Otherwise, we will also, they were kind to you.
my
You
lord.
should have been prosecuted in the criminal side.
No, my lord is correct, but my only one respect.
It's a
No, my lord, there is a
medical equipment supply.
no medical equipment that has been installed, my lord, in the presence of their officials. My lord, that the BPL. My lord,
No, we are not in.
ESI hospital has
Can you
given,
deny,
my lord,
you're facing a bit different.
my lord,
We understand
my
that.
lord is correct, but just for a moment, my lord.
Can you deny that the machine did
No.
not work even for a day and you want money?
No, my lord, not even, my lord, machine
Take it
has been,
back.
machine has been properly worked and that the ESI hospital, the
You are
appellant,
appealing for. Yes.
my lord, just the appellant has
We are
given
not
the
listening.
installation
Sorry.
report.
We are
Just,
not listening to it.
my lord, the rest of the discussion of the court, I am not going to bothering your lordship, just for a moment, my lord, just for a fraction of
Not for a
second.
second.
And the installation report that has been
All
by the
is going-
appellant, by the ESI hospital, my lord.
Keep on
They are
repeating.
saying that the
You keep on repeating that, we will not hear it. Mr. Townsend, please understand.
My
Look
lord
at
is-
your outburst.
yes, my lord. My
You
lord,
supplied an equipment worth 30 lakhs.
my lord.
That was the sole equipment which was meant for, guiding the operations in
Man.
orthopedic department.
Correct, my lord.
And then it did not work. You did
No, my
not
lord.
have it remain.
It was working.
वो तो बोलने से नहीं होगा.
My lord,
Are
their
you-
installation report
Just
is
a
there.
minute.
No, my lord.
Are you ready to have it rectified? Otherwise, we pass some other order.
No, my lord,
We
I'm
will
ready.
satisfy that order.
I'm ready, my lord. ESI hospital has to take the, my lord, has to communicate it with the BPL, but that the.
We are not concerned.
BPL is the.
You are the supplier.
My lord. And that the
We
clauses,
just allow you to be paid. Correct, simple. You
My
go
lord.
before any court. We are not giving you. Unless you take instructions. No,
Yes.
we are hardliners on this.
no, my lord, we are also communicating with the BPL.
Suppose
The BPL is the manufacturer, my
we
lord.
don't know.
And we are.
We don't know, file a case against BPL.
We are.
This is playing fraud with the.
Lordship,
with
can
the
you give a date, my lord? We have
May-
already
I will-
communicated. We are communicated
Kanoon
whatever
में-
may be the, my lord, outcome. We place before this honorable court.
आप कितनी भी बहस करेंगे मैं नहीं सुनूंगा. And I'm justified in doing this.
My,
कितनी भी बहस करेंगे हम छोटी सी point को भी I take cognizance of even small points, Mr. Counsel.
Exactly, my lord.
If you have noticed this point.
yes, my lord is correct. My lord, let me give.
Here
give
I
the
don't
time.
want.
I will get the
सुनिए
instruction.
पहले.
My lord.
I don't want to hear anything.
My,
Come up with a proposal that you will have it repaired.
my lord,
We will consider.
my lord. My lord.
Otherwise, we are going to give direction to the medical superintendent of the hospital to initiate proceeding against you in different jurisdiction. ऐसा थोड़ी होता
Can my lord, my lord, a week's time may be granted. We are already communicating, my lord, with the BPL authority.
By that time, we will stay the judgment, stay the operation of
My
the
lord,
judgment.
stay that will, my lord.
हाँ तो आपको पैसे मिल जाएगा तो बेकार हो जाएगा ना.
Well, definitely they are not going to disburse.
What kind of logic was this?
One week will not make any difference, my lord.
Sorry. देखिए, we are taking a hardliner stand, but it is for you.
My lord,
You could be the patient in the hospital.
my lord,
I could be the patient in the hospital.
my lord, I would understand.
And we know that we don't have to go by sentiments or by emotions. We
Ma'am.
understand.
Ma'am.
But this is not done.
Now, install it is fellow help and set. They are, my lord, issuing the report. ESI hospital saying it is satisfactorily
आप
working.
जाकर उसे correct करते. Not that the superintendent is hostile to you. You go,
Exactly, my lord.
have it checked, ask, कहीं से कुछ करिए, उसको working condition में लाइए. Only then we will allow. Otherwise, not.
Yes.
You can take it as long as I'm here. I will not allow this.
My lord, kindly, that is discussion of your lord. My lord, kindly give me.
In fact,
Which time, my lord? Which time?
I'm inclined to set aside that judgment with a very strong comment.
Which time?
And we do it now only. But आपको समय दिया because I have not heard you.
My lord, my lord,
कुछ नहीं सुनेंगे.
my lord,
पहले repair करिए तब पैसे लीजिए.
my lord, my lord. Which time will be granted? My lord, I
2
will.
weeks I'm giving you.
2 weeks,
File an
yes, yes.
affidavit that you are ready.
2 weeks, 2 weeks.
Go before the hospital. Say that we are doing our best. We are
My lord,
asking
my lord, we'll take care.
chance the BPL.
Yes, yes, my.
What BPL and CPL will do. We don't do such a thing. And how come the second judge decided this disputed question of fact?
Well, there is a, my lord, notification and there is a guideline by which the contractor is governed. After my lord, issuing the CRC, except
Anyway, it's no use, losing my
my
fool before a lawyer who is only representing his client.
my lord,
Agree.
my,
We are giving you time. You have understood
My
our
lord.
views.
I will take care of
Do
that.
whatever you can or
Yes.
take a dismissal,
Exactly.
take an order
My lord, I will,
allowing the appeal
exactly,
and go to whichever forum you feel.
my lord. I will take care of that.
The medical superintendent of the Employees State Insurance Corporation Model Hospital and others have preferred this appeal against the judgment and order dated 6/3/2026 passed by a learned single judge of this court in WPC number 661 of 2022 directing for the release of full payment to the respondent, despite the fact that a defective machine was supplied by the respondent. The hospital, the appellant hospital had floated a tender for purchase of a CR fluoroscope X-ray machine used in orthopedic surgeries with a 2-year warranty and 5-year comprehensive maintenance. The respondent, who is the proprietor of Arrow Medical Solution, was awarded the contract on 13/5/2021 for rupees 32,25,000. The machine in question was installed on 27/2021. And a consignee's receipt cum acceptance certificate was also issued on 21/8/2020. Stop. The contention, next paragraph. The contention of the appellant is that from the first day of the installation of the machine in the hospital, it did not work. Stop. There were serious technical problems like delayed image generation, images becoming extraordinarily wide. There were mechanical movements in the machine without the machine being put on a without the machine being put to power. Etc. In fact, the video connector was also found to be totally defective. The appellant made complaints to the respondent supplier as also to the manufacturer, namely BPL Medical Technologies. Stop. It appears from the records that joint inspections also were made where the defects were confirmed. However, despite repeated requests and assurances, neither the supplier nor the manufacturer made any attempt to repair the machine. Under such circumstances, the appellant hospital refused to release the full payment, treating the machine as defective and non-functional, even though it was still under warranty. And you want money. The supplier preferred the writ petition, claiming that the consignee's receipt cum acceptance certificate was a conclusive proof of the supply and therefore payment must be released. And payment must be released. This argument appears to have been accepted by the learned single judge in issuing the direction to the appellant to release the payment. The learned counsel for the appellant submits that the learned single judge completely overlooked the additional terms and conditions in the contract with respect to installation, testing, commissioning, training, statutory clearances, functional service center certificates, etc. The proven defects were completely ignored, and it is submitted that proven defects were completely ignored, and the consignee's certificate was taken as a proof of the supply, entitling the supplier for the full payment. the submission on behalf of the appellant is that the judgment reflects complete apathy to public money involved. First, the machine is still not working properly. And large number of patients are referred to tie-up hospitals at an extra cost to the state exchequer. So apart from that, it has also been pointed out that there is an arbitration clause in the contract, which the supplier / respondent never invoked. Mr. Arindam Saikia, you're Mr. Arindam?
Mr. PK Das, my lord.
You're Mr. BK Das. Mr. PK Das, learned advocate, has appeared on behalf of the respondent supplier, who submits that he shall take instructions as to whether a serious attempt shall be made, as to by when the machine delivered shall be made defect free. He seeks some time to get back to this court on this aspect of the matter. Let a clear stand of the respondent supplier be put on affidavit by the next date. Stop. In the meantime, the operation of the impugned judgment shall remain in abeyance. We are absolutely unhappy.
15 June. Obliged. Item 10.
Go, give him time till May. Repair it, make it workable, we shall allow. We shall allow the release of payment. If it is not workable, there is a single complaint, we shall not. Correct. It's very, very simple. Suppose this machine was installed in my house. Would I have paid? Never. Even if it were of 30,000, what to talk of 30 lakhs, I would not have paid. Don't think that the state is any different from individuals in these matters.
28-5. Please take it. 28-5. Pass.
We are giving you time till June. Repair it.
Or 30th of June, my lord. Sometime.
By that time, no money shall be released.
30th of June.
Correct करिए जहाँ से लाइए technician करिए. Then
We'll take care of
this anger would subside only then.
29 June. Holiday.
Mr. Das, this is not against you.
my lord.
This is for the reason of, you getting a direction for being paid for a defective machine, which did not work even for a day. What law? What logic? Which law? Which contract?
Initially, it was working, my lord.
Holiday. 26 June. 26 June. Item 10.
Yes.
My lordship, which is insurance order is on page 126.
What happened?
My lordship, we have been issued impugned eviction order, my lordship.
From where?
And
One second, give us a minute.
our contention is that,
What is your contention?
our contention is that, my lord, this is not forest land, my lordship. And from the documents we have annexed, my lordship, we have relied on this, my lordship.
Yes, Mr. Goswami, just tell us. Is it a forest land?
They're absolutely inside forest land, my lord. We have produced
File
the
your
map,
affidavit.
we have produced the joint verification.
Did you file that affidavit before the letter?
Yes. It has been held, my lord. There is no record from the petitioner side to, my lord, establish that.
No, you tell us.
Our record,
Petitioners are poor persons. You tell us that they were residing. In
they were residing
and they
inside,
were issued notice.
they have residing inside reserve forest, my lord.
Where have you said so in your affidavit? It was from
My
the
affidavit
forest.
is page 60, my lord.
File your response to it. Wait up.
They've already been evicted. Already been evicted. I
That's right, yeah.
instruction to that effect.
What we will do now?
Well, in that forest, my lord, everyone were already evicted. Only 3 petitioners were there, my lord. They raised the claim that they are not in forest. That's why they are evicted.
These land are having that
You
number,
have been evicted.
Already evicted.
Sorry, but
my lord.
you would have interfered if it were not a forest land. Forest land, you would have asked them to do it tomorrow.
My lord, I have annexed my lordship, this, kindly see notification.
Very well, we will admit. We will admit this as well.
Lands are having dark numbers also, my lordship.
1 and 2 are appellant, my lord.
Yes, sir, how we, Mr. Counsel, Mr. Lashkar, how do we decide that the state is not making a correct statement that it fell in forest land where you were residing and that you have been evicted? You also capitulated,
My lord, had it been in the forest land, my lordship,
Yes, my lord.
and
Joint verification, we did thrice, my lord. One for, only for these appellants, my lord.
these lands are having dark numbers, my lordship. There are patta lands also adjacent to our land, my lordship. I have annexed 1973 notifications, my
we
lordship.
cannot hear this appeal. The hate to that, we must be restored. That's a fresh action. This was against an eviction notice. We can't help it. You have been evicted, we will not restore you to possession. That will amount to restoring all others who have been evicted. And even otherwise, you can't dispute this fact that it was part of the Hikata Forest Reserve. Is that the forest reserve, Mr. Goswami?
Yes, ma'am.
My lordship, I have even relied on even their map, my lordship, which I have annexed on page 120, my lordship. Revenue and DM department, as per the revenue record, my lordship, these lands are not inside forest land.
Yeah. The appellants stand evicted from so-called, stand evicted from their residential premises, which according to state fell in Tahikata Reserve Forest area. The contention of the appellant, the eviction notice was challenged by the appellant, which could not be sustained. Hence this appeal. Hence this appeal. The appellants, along with others, had been residing in village Dubapara Lukta Chat, which falls under Bhatiapara revenue area of Matia Circle in the district of Golpara. The contention of the appellants is that their residential lands were recorded as ordinary government caste land in official revenue records. They had been residing there peacefully for generations. Upon the contrary, the claim of the forest department is that the land in question falls inside the Hikata Reserve Forest, which was notified sometimes in the year 1973. The factual position is disputed by the appellant that their houses lay inside the boundary of the forest. In fact, it lay outside that boundary, and therefore they could not have been held to be part of they could not have been held to be residing in reserve forests. Reserve forest. The appellants also rely on a 1987 official field inquiry conducted by circle officer and the deputy commissioner. Now, are recording that the lands in question are revenue department land and not forest land. Mr. In any view of the matter, on the issuance of eviction notices to the appellants on 7/10/2025 by the divisional forest officer, the appellants approached the High Court by WPC number 6217 of 2025. This court directed the authorities to consider their representations, make proper verification before taking any precipitate action. Strengthened by the aforementioned observation, the appellants submitted their detailed representations on 6/11/2025. And but a day after, किस तारीख को किया था? 7 तारीख.
6/11, on the 6/11 itself, the eviction order has been issued.
Representative of 6/11/2000.
The day we submitted
On the
the
same day, the eviction order was passed by the forest officer, rejecting the claim of the appellant and fixing a date for eviction. The appellants claimed that this was a hurried order and a hurried order without any verification of the claims of the appellant.
then we filed
The grievance of the appellant said that the learned single judge in this instance accepted the stand of the forest department that the land in question fell inside the reserved forest area, but did not consider the fact that notwithstanding a previous order of the High Court of verifying the correctness of the contentions raised by the appellants, on the day of the representation preferred by the appellants, the eviction orders were passed. The appellants claim that if the revenue records are verified, along with the 1987 inquiry report, it would appear that there is no joint demarcation. They also argue, the appellants also argue their right to shelter under Article 21 of the Constitution. For the reason that the appellants stand evicted on 31/1/2026. The claim in this appeal is for restitution. This application, this appeal is required to be heard. This appeal is admitted for hearing. This appeal is admitted for hearing. List this case at the hearing sometimes.
highly obliged, my lord.
16 July.
In the meantime, Mr. Goswami, Mr. P. Goswami, letter additional advocate general shall put in the affidavit on behalf of the state, with necessary proof of the fact that the land from where the appellants have been evicted fell inside the reserve, the Hikata Reserve Forest.
Highly obliged.
Item 11.
Yes.
Matter was matter is about the secrecy of both, whether it applies in panchayat or not. This is one.
Don't filter your argument to one liner. I will not.
So this is the point involved in the case.
Point is involved.
There, whether the person while just giving vote, he just flashed it in torchlight and he took away that ballot paper.
The picture.
Picture with a picture.
I don't understand the background facts.
Oh. Fifty-four minutes.
Tell us some facts and then you come to the point.
Yes. Fact is, madam, your lord, in the indirect election, the panchayat, in the initial election took place, madam. 10% elected. Now, next turn is, madam, that to elect president, vice president. So in the election of vice president, madam, two candidates were there, madam. So one candidate, what he did, madam, in support of one, he voted in favor of one, present petition number one, madam, respondent number one. And while giving, madam, he has just took out a picture of that here, madam. It was cancelled by the returning officer. So total 5 and 5. So one person less than 5. So I was declared to be president. Madam. By speaking order, that was the final appeal. That came before the court. This court directed them to approve that deputy commissioner. Deputy commissioner might have passed speaking order.
Not
In my
releasing.
favor, might not asking that consideration was justified. Upheld, madam. Again, that we came before the single bench. Madam. Single bench might not what they have come. And similarly says that was section 128 of the Worship and Representative People Act.
वो कहाँ लगता है?
So it says, my lord, that this does not apply. In the Panchayat Act, my lord, secrecy of vote applied only in case of 5 conditions. If these 5 conditions, any one of that, my lord, it will be concerned. Now the question, my lord, section 54 of the Panchayat Act, residual power. If anything is not provided in Panchayat Act, the Representative People Act will apply. This is the law. Panchayat Act. You also can see election 54, next page 2. I had just might have, instead of book, might have, I had just noted it in the.
Let us see the order of the deputy commissioner.
Yes, it starts from page 87.
Page?
87
No, 76. 76.
or 70, speaking order. Yes, madam, 76. Yes, annexure 9. Your lordship will find past meeting that we should skip might have done. Whereas there the house is resolved to have an election in this matter, your lordship, second paragraph. Through the ballot papers, where the candidate, namely Shahida Ahmad, got 4 votes, and Eloha, present appellant, madam, got 5 votes. So this is the then your lordship will find. Whereas in the case Shahida Begum, she approved this honorable court challenging the cancelling the vote of Mohibul Haq and the first meeting so and so. A writ petition was filed and it will direct the district commission of Gauhati to dispose the said representative in the matter indicated therein within 30 days. Then it was where notice issued, then hearing district commissioner, then your law kindly see whereas on 14/8/25, both the parties appeared before the undersigned and gave their statement and district commissioner Gauhati and heard them. In the process of hearing, while the jurisdiction of district commissioner asked Shahida, that is my respondent number 1, to clarify her alleged matter, she stated that Mohibul Haq, that is my person who has might have taken that he might have had flashed the light of his mobile while casting his vote inside the polling station, as it was dark at the moment, to ascertain that he had casted his vote in the right place or not. Whereas the authorized officer was sitting outside the polling compartment and on seeing flashing of light, authorized officer assumed that Mohibul Haq had clicked pictures of ballot paper, and on that basis, authorized officer has cancelled his vote, and also she emphasized that Mohibul Haq had clicked picture by flashing his ID, but there was no records of sharing the picture to others, and perhaps he immediately deleted it from his mobile. There is no evidence of clicking photo of the matter, so and so, therefore, she insisted to the authority that the vote of ward number so and so should be considered and not cancelled. Then I take your lordship to second paragraph.
Just Now, what happened pursuant to the order passed by the learned single judge, has the exercise been created by toss of vote? Because we are, Mr. Chaudhary, we are in agreement with the learned single judge's order. Because there are definite grounds on which a vote could be cancelled,
That is in the Panchayat Act says.
Yes, 46(7).
Yes, yes, it is there, madam, we have given madam
Posting
46.
list of grounds on which a ballot paper can be declared.
Yes. In the Panchayat Act, but secretary board is not mentioned here in the Panchayat. But this is dealt with,
10 persons, he voted and for
Right, madam.
for record's sake, he.
But
picked a photograph.
ultimately, my secretary to be maintained, my lord.
No, no.
That is the election matters, my lord. You will kindly see page 54. Next page, but my handwriting, but that handwritten, my lord, that here. 54. Now, secretary is there, my lord, conduct of electoral 90 section, rule 39. 39, my lord. Maintenance secrecy voting by electors, my lord.
We are not inclined. We go
Madam, your lordship to see,
entirely by the judgment of the learned single judge.
Madam, madam, your lordship is to see whether that provision applies or not. That is your lordship to settle that matter,
It
madam.
doesn't apply.
If your lordship say, I have nothing to say, madam.
You argue.
But in my humble opinion, my lord, because since 54 is something, so object of legislation is there, my lord. 54, my lord. Rule 39, my lord, conduct rule. So I just have a look, my lord, in my handwritten note, my lord, page 2, my lord. Rule 39. Right, it's my lord, rule 54 of the rules, my lord.
Where is the mandate of not taking a photograph?
My secretary, my lord. Question, my lord, once.
And what would it be?
Maybe that, my lord, he was influenced by somebody, my lord. And he wanted to show that, yes, I have given good in the favor, my lord. So, my lord, at least, my lord, your lordship is to be.
Let us just fight. Let you and respond number one fight, we might defeat each other in the election. Both of you have to obtain the equal number of votes.
Now, luck will play, my lord. Luck will.
Let it be decided.
No, whether when the law is there, my lord,
We have followed.
now, if your lordship say, my lord, if it is not applicable, let the law be settled, my lord.
Say that in our.
That's the thing. It is up to your lordship, my lord.
There's no breach.
Um,
We have heard Mr. H.R.A. Chaudhary, senior advocate for the appellant, and so for the respondent. The appeal is dismissed.
Obliged, your lordship.
Item 12,
There is an advertisement for filling of the post of about 552 land record assistant. And I just.
Many matters in April. With respect to this. Yes. The challenge to the Assam rule
Yes,
of prohibiting any person from Hima Asa or any other scheduled area to participate in that selection process. That is under question. Are you aware, Mr. Boswell?
Yes, my lord. The date, the last date of application is 31st.
Beats the case before the last date of.
Only
Mukherjee was there in that case. Before and made an interim here.
Let this
my
matter.
only concern is that my lord, their application should not be.
Let this matter be listed along with WPC number 143 of 2026 on 27/4/2026. Give him a copy of the order.
27?
Well, in the meantime.
Last date is
Yes,
31. Last date for application.
Therefore, we have fixed it 27.
Hopefully, my lord, it's.
The reason that many such applications are coming.
That's all.
See, the employer needs that you have a separate system.
No, even then, my lord,
You have taken training sponsored by your state. And then we'll see the constitutionality.
Yes, yes.
Let's see, 27.
Let's say from Assam, one can go to NCL, from NCL, one can come and compete in Assam. There is
You're
no
right.
sort
That's
of
an
bar.
argument. That's an argument which we shall take into account. Mr.
And that is what it is now. Article 14.
These matters we argue.
It cannot be limited to one place. That no, only Assam is only Assam, NCL means
Big
only
brother.
NCLs. This will
Big brother,
create-
the challenge, the
This will
usual
create-
refrain is big brotherly attitude. We will do everything, we'll not accept from there. Let's see.
27.
In the lead case, my lord, that is WPC 143, my lord, we are going to find the affidavit shortly, my lord. That will cover. And so,
Say this is the affidavit which shall be, which will suit the, which will be needful for all these petitions and serve a copy of Mr. Secretary.
absolutely.
Item 14.
May it please your lordship. So this is a BIL for implementation of the bail fund scheme. Lordship, an affidavit.
We'll come back after 5 minutes.
Bill pertains to implementation of the bail fund scheme. Lordship, the State Legal Service Authority has filed an affidavit. I'll just highlight certain aspects of the affidavit. Lordship will have page 295.
Just a minute, give us a minute.
Yes.
Yes.
Lordship will have page 295, which is a table supplied by the different districts as to the status of the scheme.
95 here.
There's a table annexed in the part of the affidavit. Lordship, there are 6 districts with 116 individuals where the cases have been
Where are you referring to? Page 295?
295. Lordship should be a table. Lordship, there's a table.
There's a table.
Lordship will have entry number 3, Kamrup Metro.
Yes.
There are 80 cases
Yes.
with a surety amount in total of around 11 lakhs. Lordship will have the comment. Recommendation for payment has been sent to IG Prison to the Superintendent of Central Jail Gauhati for depositing the amount in the head of accounts of the Office of the CJM Kamrup and awaiting for reply from the IG Prison. Lordship will thereafter have entry number 8, Kachar. There are 41 cases pending with IG Prison since 18/12/2025. I will not place the other entries to Lordships, but there are at least 6 such districts with 116 individuals where the cases have been recommended, but they are awaiting disbursement of funds from the IG Prisons, which is the respondent number 4. Okay, this is the first.
Mr. Chatterjee, the directions that it must, be distributed so that they come out of the jail.
Actually, one of the
Now,
identification.
therefore, the committee is there to ensure this, no? What is this effective implementation?
Well, the district level, AMR committees, they have identified the,
When was the last meeting held of the committee? Because this figure does not satisfy us. Mr. Chatterjee, Chakravarti, please understand it. Chakravarti is also called Chatterjee, no?
No.
Chakravarti is in Chatterjee.
Chakravarti is Chatterjee.
Chakravarti and Chatterjee. Mr. Chakravarti, you understand this. Now, that the scheme is in place, no doubt. That money has been allocated, no doubt. But it has, for proper implementation on the ground, the committee must meet, the committee must ensure. Since 2025, the IGP has not responded. Can't be known. Where is the committee sitting? What is the committee doing?
Actually,
Please, this affidavit needs to be updated.
my lord, I have
This
seen,
statistics does not satisfy us. If it were only on paper, this scheme would have satisfied.
correct, my lord. In month of January, there are some meeting, my lord,
Please
reference
give
for
us
month of January.
an updated version, this presentation, and who is the member of the member secretary of Assam State Legal Services Authority.
Respondent number 4, the IG presents.
Who appears for respondent number 4? You file an affidavit, give a copy. Give a copy to him,
Yeah, already submitted.
already sir,
We have-
you also file yours. Mr. S. Gorwal and counsel for the state of Assam submits that the affidavit on behalf of, we are not giving any direction, you should have filed that affidavit. Member secretary is a judicial officer, he is doing whatever he can. The responsibility lies with you for implementation. Now we'll throw the entire blame on you, Mr. Barwa. Why do you have to do that?
After going through, we'll definitely file.
Affidavit on behalf of respondent number 4.
Respondent number 5.
Respondent number 5, in view of the affidavit on behalf of the Assam State Legal Services Authority shall be filed positively by the next day, re-notify on. We are giving you 4 weeks, file this affidavit. Correct. You guys, I think will not have many persons to serve the affidavit. We keep it in first week of May. Today is Wednesday, no, 6th of May.
Update.
Item 15.
Yes.
May I please the lordship? Lord, in this case, the petitioner, by way of this public interest litigation, is praying for involving a mechanism by which the scheduled caste or scheduled tribe certificate of a prospective candidate for election to the state assembly or parliamentary election is scrutinized by the state level scrutiny committee constituted in consonance with the judgment of the apex court in Madhuri Patil's case, reported in 1994 6 SCC 241. The petitioner has earlier approached this honorable court on the administrative side, and the reply has been sent by the registrar judicial, giving him the option to file representation before the concerned authorities. He has accordingly done so, but he has not received any response. So he has been constrained to file this public interest litigation.
That would, this would derail the process. We will have it in place sometimes later, not necessarily before this.
Before this election, it is not possible.
That is not possible.
It is not possible.
So therefore, we are looking at it from the urgency with which you have filed this petition. For the,
Yeah. So far as this election is concerned, it is not possible.
take up. We have heard Mr. P. Bhomik, learned advocate for the petitioner. Through this petition, he seeks to address a systemic issue in Assam's electoral process for reserved constituencies. A direction has been sought in this petition to the respondents for creation or a strengthening of a mechanism to verify the genuine SC or ST status of candidates before they file their nomination paper for elections to the Assam Legislative Assembly or Parliament from reserved seats. Who are you?
I belong to a scheduled caste community. I have been representing public interest. Rashid, I have stated my credentials.
Currently, the practices of candidates submitting their caste certificates, which in most of the situations are based on recommendations from community associations. The contention of the petitioner therefore is that this certification is prone to misuse. The risk, therefore, of fake or incorrect claims allowing a non-belonging person to contest and win reserve seats meant for genuine SC/ST candidates. What did I say? What did I say the last slide? It therefore. There is therefore, yes, is not imaginary. And if it happens, it would undermine constitutional goals of the representation of disadvantaged communities under Articles 330 and 332 of the Constitution of India. Next, a proposal has been made in the petition of making a verification certificate from the state level scrutiny committee mandatory at the nomination stage, in addition to the regular caste certificate. So this would perhaps ensure that only authentic SC/ST candidates represent reserved constituencies. Preventing fake claims fake caste certificates are not new. The petitioner relies on the Supreme Court judgment in Kumari Madhuri Patil and another versus Additional Commissioner, Tribal Development and others, 1994, 6 SCC 241, where guidelines have been laid down to curb fake caste certificates. So in that case, a direction has been issued to the states to constitute the state level scrutiny committees to verify the genuineness of the claims of the person and the certificates issued to them in that regard. The composition of such committee includes responsible officers of the respective departments who have an expertise in tribal identification. In fact, in Madhuri Patil Supra, the Supreme Court also recommended for setting up of a vigilance cell headed by a senior police officer to investigate claims and counterclaims. It is admitted in the petition that the state of Assam has constituted such state-level scrutiny committee with the backup support from Assam Institute of Research for Tribals and scheduled castes. Which two has been made a party in this petition as respondent number 7, comma, which maintains relevant data. The reality of the ground pointed out by the petitioner is that as on date, 2,000 applications, 2,000 complaints are pending before the committee, are pending before the state level scrutiny committee, which exposes the system to vulnerabilities. Many examples have been cited in the petition. Where non-belonging persons have been given the advantage of the caste set in the absence of strict scrutiny and verification. Strict scrutiny and verification. Under the aforementioned background facts, the prayer in this writ petition is for a direction to the respondent to make it compulsory for the state level scrutiny committee to ensure that a prospective candidate for an election in the reserved constituencies in the state of Assam actually belong to SC/ST community. Or else to suggest any mechanism for ensuring if a foolproof, fail-safe scrutiny of candidates. The grievance appeals to be genuine. With notice be issued to the respondent. Notice to Union of India, Election Commission of India, and Election Commission of India is accepted by by Ms. S. Katikul, standing down from ECA. And the Chief Electoral Officer. Notice to response number 1 to 3 is accepted by Ms. S. Katikul.
2 and 3.
Huh?
2 and 3.
Oh, well, one is the Union of India. One is accepted by CGC. One is accepted by the learned CGC. 2 and 3 by Ms. Katikul, Standing Commission, Standing Council, ECI. I think you can accept it for 4 also.
Four, there is the standing council.
Mr. Dubey.
Mr. Dubey was sitting here, I saw it. Just inform Mr. Dubey that we are telling
Yes.
Mr. So-and-so Dubey for respondent number 4.
My lord, for 5 and 7, I will be.
And to Mr. So-and-so, Mr. S. You are Mr. Ardhar. Mr. Ardhar
For 5 and 7.
accepts notice for 5, 6, and 7.
No, 5 and 7, my lord.
5 and 7.
6 is a my lord private.
6 we are not asking. 5 and 7. Let the learned advocates appearing for the respondents respond to this question.
My lord, one thing only. There are 2 scrutiny committees, my lord. One is for tribal, that is I'm appearing. There is another my lord for SC and OBCs.
You first suggest from your side, please.
My lord.
Like,
You must be genuine.
My lord.
We are aware of many situations where people, I mean, even with respect to our giving benefits to the people from the community. The certificates are more often than not found to be
No,
false.
but my lord, basically in the state of Assam, a certificate is issued, my lord, on the recommendation of the, my lord,
Please look at the examples which Mr. Bhomik has given,
my lord.
and then you say that your system is foolproof. Look at the examples. And what is the purpose of keeping these petitions pending before the elections? Some of them you never know would be candidate, would have filed nominations.
I'm told one has already filed.
Therefore, please don't, let us not, I mean, this is true for us also. We may not pat our own backs. Let's see where, if it has been pointed out, we must,
That is why, my lord, I submitted that there are two scrutiny
we are
committees.
not concerned. You first do your part.
My lord, my lord. I'll do that.
May I have a date
12 June. 12 June.
of like,
After the,
after summer vacation?
17 July.
Like,
Item 16.
It is feasible. If this links into this, I'm seeking to raise the issue of civilian conflict in the state of Assam. Lordship,
let me get into it. I think one key is. Yeah, correct. Yeah, correct. This world belongs to them. It belongs to them. We are intruders.
Lordship, only one legal issue.
Do you agree to this statement?
Yes, yes, absolutely.
A Chief Justice of Delhi High Court, while driving back to her home, she found that a monkey was trying to eat something from a garbage box. She came back, held court, and issued certain directions. And in that introduction, she said that this world belongs to them. We are total outsiders.
Absolutely. Lordship,
तो क्या करेंगे हम?
for that reason, Lordship, the Ministry of Environment has issued certain guidelines which calls for a cross-sectoral addressing of this issue across departments.
So this कैसे करेंगे? What can be done? No, they will always cross over. We can't keep them in cage, all of them. We
No,
can't catch them.
That's not.
It will be another petition like street dogs.
Yes, yes,
You
yes.
don't ask us to do that.
Lordship,
Yes, they respond, Mr. Goswami. We are not writing any introduction to this question.
let notice
Let-
go on.
Yeah. और फिर वो dog वाला issue हो जाएगा. We don't want to enter into this.
The vaccination also comes.
Their presence cannot be avoided.
Lordship,
Especially especially in a place like Gauhati, which has a lot of green cover.
Yeah.
A lot many trees in the neighborhood.
Lordship, for that reason, I have added respondent number 8, which is the Animal Welfare Board of India, which is charged under the.
I was studying I was in a hostel which was just on the bridge of Delhi.
Yeah.
I mean, which hills? Sahyadri Hills. Not Sahyadri, but the ranges. The last of the Himalayan ranges. This was Jubilee. I had gone to the dining hall for having my breakfast, came back and saw that the window was open. It overlooked the ridge. A big monkey was there. It was turning the pages of very old dictionary of mine, which I had inherited from my grandfather. And he was turning each page, pulling it off and throwing it. He couldn't do anything. So I asked one of the peons, working to bring a stick. So he got hold of that stick and I was about to be bitten. But then nobody took that seriously. And then it was during those days, sometimes in 1990s, late 80s, that I realized that the world belongs to them. It was actually their place of abode.
Absolutely. But we are only praying for a human resolution to the issue, and the Animal Welfare Board of India has expertise in that.
David. In view of the issues raised in this petition regarding widespread and escalating human civilian conflict caused by the unchecked proliferation of rhesus macaques across both rural and urban areas of Assam. We ask the learned additional advocate general Assam, Mr. Goswami, Mr. P.N. Goswami, to respond to this petition. An affidavit in this regard be held positively by the next day, re-notified sometimes in July.
17th July.
Yes.
Item 17.
May period. 16. Yes.
Actually, I was a headmaster, in charge headmaster. In 2023, what happened due to some incident, midday meal, in the midday meal, some students sick failed. Then thereafter, I was suspended for 6 months.
Who are you? You're principal of this.
In charge of the headmaster.
In
charge
Yes,
headmaster. Then after 6 months suspension, I paid for revocation my letter. Then Lordship DO had written that I was not responsible, but helper come to was responsible. Then Lordship, then into another was passed that no, you are also in charge as master, you are responsible. So one increment has been curtailed and in charge as master has been given to my next junior, which is tutor. Then Lordship, what happened? After this, I opposed before this honorable filing a petition that.
Did any student die?
No, nothing. No
Failing.
failing. But thereafter, no.
And what was discovered? A lizard.
No, phenyl bottle was there. Phenyl bottle was there. Some forthcoming officer says, but no inquiry report. Lordship may produce page number 46. What page number 46, there are 9. This court finds that nothing, no supposed notice has been given, no inquiry, no nothing has been given, and court upheld that yes, they should be set aside.
Then what happened?
Then from the Lordship kindly see page number 46, para 10, Lordship, 9 and 10. This, may I read, Lordship? Para 9. This court, having found that the procedure prescribed under Rule 9 of the rule of so-and-so to have not been followed in the matter, the order dated so-and-so cannot be sustained and would be mandated to be interfered with by this court. Accordingly, in view of the above, the order dated to the extent to impose a penalty of scope increment without cumulative effect upon the petitioner stands set aside. However, the order of revocation of order of suspension of the petitioner as effected by the so-and-so is not interfered with. This is disciplinary authorities have granted liberty to proceed against the petitioner if so mandated by instituting the regular department proceeding against her in compliance.
Yes, Mr. Katniya.
Still such date, Lordship.
Whatever. First, he or she would be responsible for it. But then if you're relying on some part of inquiry or disciplinary proceeding which you started, a rudimentary kind of a domestic proceeding, I think the report on which you relied had to be given to the person concerned.
That has not been followed, madam. That is why Honorable Singh has interfered with, madam.
Then what happened? Suspension.
Page number 36, Lordship. Second part, Lordship. In charge headmaster was 30, Lordship.
Just a bit. Let me see. It's all right. You're not under suspension now.
No, sir. My headmaster, till the department proceeding,
Let the department take a call whether they would like to proceed against it.
yes. If they are proceeding, I have nothing to say, Lordship. But
They
me,
have
my,
not proceeded.
yes, Lordship. No department proceeding.
Yes, what is your statement, Mr. Khatanya?
Because my lord,
Are you contemplating of proceeding against the appellant?
that information I have to obtain, my lord. That
Or
is-
instruction,
Yes.
otherwise she can't be divested
Yes.
of her.
That's it.
This is punishment again.
Lordship.
If you want to initiate a proceeding, even if it is in contemplation, all right, please, my lord, we'll wait for it.
Yes, sir. But my experience was here for 4 years. Same department has not initiated.
That doesn't mean anything.
Lordship.
Once you have failed, you have failed. This is a world full of competitors. Your competitors are there. And then the appellant who had been the head teacher of a school in Nagaon district faced a disciplinary action after an unsavory incident occurred on 17th of May 2023, where 73 students who had consumed midday meal had fallen ill with symptoms of food poisoning. Next. She, as in charge head teacher, was held prima facie responsible, along with the cooks and helpers, leading to her suspension, a minor penalty, and removal from the head teacher charge. This was challenged by the appellant before this court by WPC number 5963 of 2034. The minor punishment of stoppage of one increment without cumulative effect was found to be without the procedure prescribed under Rule 9 of the Rules of 1964, to which the appellant was subjected. The order passed by the departmental authorities visiting the appellant with such punishment was set aside. The court agreed. The court ratified the revocation of suspension of the appellant. Simultaneously, a liberty was granted to the disciplinary authority to proceed against the appellant, if so mandated, if so desired, by instituting a regular departmental proceeding against her, but in compliance with the provisions of the Rules of 1964. Till such time that the proceedings would be initiated and concluded, the learned single judge upheld the directions issued by the Director Elementary Education Assam on 5/6/2024 to not allow the appellant to hold the charge of the post of headmaster. What did I say? No, उसके पहले. Yes, but made it subject to the outcome of the proceedings if instituted against the appellant in the matter. The learned counsel for the appellant is submitted that no departmental proceeding has been initiated against the appellant now. And in that case, the appellant ought to be given the charge of the headmaster of any school for the reason that charge of the school. The Mr. Patniar Learned Counsel for the Education Department submits that he shall take instructions whether any departmental proceeding of correction against the appellant is contemplated or has been instituted. Let this matter come up for consideration. Give a date.
Let's.
29 May. Item 18.
May I please?
I think civil matters are being heard, no?
Yes.
Yes, photo.
With petition 239/26,
When is the date fixed?
18th of May.
You have the order.
Yes, Madam.
Can we have a copy of the order?
Yes, sir. Yep. In petition,
Disposition. Here you have no apprehension of being dispossessed to something.
yes, but I have that apprehension. Because I have not been served with the copy of the notice. If I am dispossessed, now I will not be able to show the.
Petition. Let this appeal come up for consideration along with WPC number 239 of 2026 and 1303 of 2026, which are listed, which are to be listed before this court on 18/5/2026. The appellants in the meanwhile shall not be dispossessed. This thing shall not be restored to this appeal in the meantime.
Like.
Is your presence coming in the way of construction of any project or something?
Same issue, Madam, in those cases, airport development.
Yes, please be ready on that. Yes. We will not forestall any project. Yes. Their concern would only be compensation, whether under 60, whether under the old law or under the new law. They can't come in the way of the state acquiring land for the purposes of, infrastructure. Yes. We can't, we will not stop it. So these entering orders are also unnecessary. We'll decide about which law to be applicable to them for payment of compensation. Be ready on that. Ask the learned advocate. I will. Not extra copy. So give copies.
Item 19.
Motion on appearing for exponent number 3 and 4 motion. Lordship, in here, Lordship, DMS already passed the order, Lordship. DMS already passed the order, Lordship.
DMS already.
Yes, Lordship. Yeah, we have challenged the
That
order
has
in
not been
DRT.
executed. Order is passed, but not being executed.
Lordship, we have challenged this order.
Challenge them. Challenge them. Put it on
Lordship,
record.
we have challenged this order, Lordship.
You have challenged them.
Yes, Lordship. In DRT, Lordship, we have challenged this order.
DRT is.
Yes, my matter is pending, Lordship.
Yes.
But
If you the respond number two, slash district magistrate have already passed an order which has been subjected to challenge by response number 3 and 4. This petition has become infractions.
Page number 37, my lord. Kindly come to page number 37.
Order is passed, they have challenged it before DRT. What do you say?
Your Honor,
Appear there before DRT.
well, we have already appeared and
they are appearing before the DRT.
If you're appearing before
Yes.
DRT, then you should not press this application.
Well, there is no, there is a conditional
No,
issue, but
Lordship, fact has been not disclosed.
let me,
It is complete. Yes.
my lord, they have approached the DRT and DRT has passed conditional order that you deposit 50 lakhs within 1 week, but
We
they have
don't know.
failed.
The subject order of challenge. You have come here with what prayer? We have, let this court not make you understand what is the scope of your petition.
Well, they have
You
not,
understand?
the,
Anyway, we have dismissed it as a infraction. Still in next. You don't understand. We
Item 20.
keep on repeating.
Highly obliging.
You came with a prayer. That prayer is over.
no, my lord. We have,
You are execution.
Yes,
Death
ma'am.
order.
Yes,
Now,
ma'am.
it is under consideration before the death order has been executed.
They have not challenged the DM order, they have challenged the personal notice, madam.
Whatever it is. Now, this is not the forum where this can be argued. Otherwise, we would have dismissed.
Item 20.
Obliging.
20. Lord.
May I please, Your Lord? Here, my lord, the petitioner purchased a plot of land. On the basis of an NOC, Lordship will find page 31. And Lordship has passed an order.
Just a minute. We have passed some order.
Yes, on 28/7, I think.
Yes, who appeals for the bank?
Lordship. I'm appearing for the Punjab and Sindh Bank on behalf of M. Sharma, Lordship. Respond number 3 and 5.
तो बोलिए क्या बोलना है?
And Lordship, we may be allowed to file our reply in this matter.
You should have filed it by now.
Lordship, we have instructed to appear.
These
in
are
this
urgent
matter.
matters. We are not in all cases of, not in all cases involving Sarkozy Act, we interfere. But here it's an urgent matter. You, with all valid known encumbrance certificates, you have purchased the property and you have not even impeded the original owner of the property.
1 week
It
time.
goes against the rules. Security, what is it? The rules of 2002. Enforcement rules of 2002. Who appears for you? Who is your senior?
Mukesh Sharma, Lordship.
कब फाइल करेंगे आप?
1 week time may be given.
Yeah, what is your name?
S. Yasmin.
I'm Miss S. Yasmin, junior to Mr. M. Sharma, who represents response number 3 and 5. Submits that the affidavit on their behalf shall be filed positively by the next day. Re-notify on your date after 1 week. It would be
30th April.
Much obliged, ma'am.
Item 21.
I appear for the respondent number 5, essentially between two banks. Seek some time to file a reply. There's a legal point more or less to answer.
Yes,
Yes, Lordship, I'm for the petitioner.
what do you want?
Lordship,
As jointly prayed for this.
Respondent number 6 today I have filed.
yes, Lordship, I have received the copy.
As jointly prayed for release this matter also. After 4 weeks?
Look, there was an order operating minutes earlier that may continue.
Any interim order, if interim order, if any, shall continue in the meantime.
Okay.
20th May. Item 24.
This Madhav Vigrah temple, my lord.
I would say the matter can be, my lord, disposed of with a very short order. What happened, my lord, the deputy commissioner is not, my lord, taking up the management of the, my lord, my lord, temple. Only because, my lord, there is a decree of, my lord, 1903 of the.
Yeah, but that decree would not come in the way of
Yes.
the new act.
Yes, my lord, that is what you have also
You heard it. I heard this matter first week of my coming here. Anyway, let's speak about it. My lord, let this matter come up for consideration. Give a date sometimes in May.
19th May. Item 25.
Might be worship, my lord.
Yes.
Your worship, can you see your worship last order, my lord? 18/8, my lord. Martin.
18/8.
18/8/25.
Oh, yes. Yes, what affidavit, Mr.
We have filed two affidavits. Pursuant to Lordship's last order, we have filed the detailed project report, tender proposal floated, work order issued, everything we have filed. Kindly take up our affidavit, filed on 10/3/26.
Can you tell us the page number?
Starts at page 104. 10/3, page 104. On 21/1/26, Lordship has directed us to file the affidavit bringing the detailed report on record, my lord.
Yes, does it satisfy you?
My lord, was it question, my lord, because there is a comparison, because they say it is outside not populated area. And our specific, my lord, case is that, my lord, you must kindly say page, my lord, first, kindly say page 99 of my, page 99, what the rule says. Rule is, my lord, waste management rule 2016, on the page 99. Site selection, your lord, site selection. Your lordship will find 7, Roman 7. Page 99, my lord, schedule 1 of that waste management rule 2016. Criteria for site selection. I take your lawsuits to Roman 7. And hopefully
While selecting the site, Mr. Nath, have you complied with this?
no.
Well, in the affidavit we have filed.
Affidavit you have filed that you have started, the work has started.
Yes, but yes.
No, it is in, the charge is that you may have done that. They don't dispute it. They say that your selection of the landfill site is not in accord with the specifications for sanitary landfill. Under the rules.
But in fact, the site has been selected after the due deliberation
No,
and
so where is that
compliance with the.
statement that
Yes,
all
yes.
rules and acts and regulation has been in that regard followed for selection of the site? We will, I mean, if there is a minor deviation, we shall not interfere. First, see, waste is generated every day. That has to be controlled. I mean, that has to be remediated. That is for sure. You, for that purpose, you've started towards, making available the dumping, what is that called? MRF.
MRF and compost meat,
Material recovery facility.
that is undergoing, that is under construction. But in the first affidavit, we have said, what their basic grievances, my lord, that the particular site which we have chosen, that is near the school, near the mandir temple. But in our first affidavit at page 61, relevant page, kindly page 61, my lord, paragraph 8 and paragraph 10, we have said that it is 700 meters away from the mandir and about 1 kilometer.
Therefore, this is the site that you have chosen is in accord with the schedule 1 specific.
Yes, my lord.
No, my lord. For that one, what I propose to suggest, my lord, that your pollution control board is also party, my lord. And as per rule 16, my lord, your lordship will find, they also got that power, my lord. Rule 16, my lord. And the criteria for selection, my lord, that in the waste management rules, my lord. 16. Rule 16. Page 94, my lord. Page 94, pollution board, my lord, your lordship.
Mr. Nath, you file an affidavit. Now, a fresh affidavit, 2-page affidavit, saying that all this MRF and other things are in accord with that. Schedule 1 specific. And in the meantime, try and expedite the construction process.
Work is going on, we'll file the affidavit.
Pursuant to the complaints made by the petitioner about the dumping site having been created near a temple and a school. It was submitted on the other state that the site has been selected. two projects of material recovery facility and compost pit, which have been sanctioned by under the Swachh Bharat mission. With respect to the development towards completion of the project, towards conception and completion of the project, it has been submitted on behalf of the state that a detailed DPR has been prepared by expert bodies, which was engaged by Swachh Bharat mission. The tender also has been floated by Howli Municipal Board, pursuant to which work order for construction has been given to Messrs. DLS Envirotech Corporation Private Limited. The progress of the construction of the material recovery facility has progressed to 25%. And it is expected that the project will be completed in near future. It has also been submitted that the landfill site and the sides of the material recovery facility and compost pit is in accord with the rules in that regard under the solid waste management rule.
2016.
The Mr. H.R. Chaudhary and its senior advocate for the petitioner, however, disputes the aforenoted factual assertion. Mr. D. Nath Leonard, senior government advocate, submits that he shall bring on affidavit. He shall assert on affidavit that the state shall assert on affidavit that the choice of the dumping site material recovery facility and compost pit is in consonance with the rules in that regard and the specifications for sanitary landfills under the solid waste management rules of so and so year. Declarants. Let such an affidavit be filed solicitorily by the next day, 345 May.
29th May.
29th?
29th May. Hello, brother.
Published.
Item 26.
Just a minute, Mr. Boyani, let us go through our order dated 1/9.
My lord, my lord.
It's a detailed order.
Order plan it. Welcome.
Yes, Mr. Boyer, you teaching ASME subject and not social science.
My lord, actually, I am in the bias
How
code,
do
my
you
lord.
dispute this factual assertion?
No, my lord, it is not a dispute on factual ground, my lord. The records which is maintained by the, my lord, Dias authority, my lord, wherein, my lord, I had been included as a teacher teaching all the subjects, my lord. So therefore, my lord, the
Your affidavit, no?
no, my lord,
Which
that,
was taken into account.
my lord, may kindly turn to page number 61 of my appeal, my lord. My lord, why he had been recommended, it has been, my lord, recorded herein, my lord.
Respond number 6 and 7, have they filed their affidavit?
Yes, yes, my lord, they have filed, not 7. 6 has not filed, my lord, only 7 has filed, my lord.
No, we require, who appears for respond number 6?
Me, madam.
Why have you not filed? The dispute is basically with you. You have been recommended by the district legal scrutiny committee.
No, if your lordship looks at the para 18, that.
Why have you not responded?
Well, I can file immediately.
You can, it's, are we giving an invitation to me?
It's not that, my lord.
Then, and you are also intermediate. You're only intermediate pass. Now, if Mr. Bhuya is not competent enough to be given that for his services being provincialized, neither are you. Where is your affidavit that you're not only higher secondary pass? And you're inviting the court's attention to other parts of the brief.
My lord,
Holding a power on behalf of respondent number 7 and not choosing to file your affidavit.
I'm sorry, my lord, I'll file it within.
And then you couch your statement in such a way as if we are inviting you to file.
No, I'll file the affidavit within 3 days, my lord.
Otherwise, my lord, the villain, he tried to unsettle the settled matter, my lord. After 21 years, he questioned the seniority, my lord. 20 years.
If he's a
20 years, he has a silent. My lord.
Mr. Sir, we are not concerned with you.
My
Your position remains in violation. When you sit down, you have filed your response, he has not.
No.
Then we set aside the decision of the committee. They have not heard him also.
My lord, I'll file within 3 days.
This wisdom dawns upon you only when the court says so.
My lord, only if your lordship looks at para 18.
Mr. D, your DA Kayu, your
No,
Mr. Abadi.
Abidin.
Mr. J. Abadi, learned advocate who has appeared for response number 6, supports that he shall put in his response by the next day. Re-notify on your date in June.
19 June.
On or before which date the affidavit must be filed. The response affidavit must be filed. Response affidavit or response of 6 months. Hello.
Supplementary list 32.
And you have to explain, why should you be allowed to continue as a provincialized teacher? You were not qualified. And it was for this reason that you were teaching, those were the days.
Yes,
But then that educational threshold qualification is necessary.
Yes, my lord.
In that case, if he loses, you also are a loser. You would be a loser if we look at it from that point. How come you decided not to file an affidavit in your response? This sword was hanging on your head squarely, just above your middle skull.
My lord.
Mr. Abidin, don't take your responsibilities lightly.
I understand.
Item 32.
Preparing for the private respondents. If not receive a petition copy may be served, and I'll file my affidavit in opposition.
Mr. Sharma, you're not.
I'll serve my.
Mr. S. Nath, learned advocate who appeals for private respondent, submits that he shall be filing a response to the petition. So, Mr. Sharma, Mr. B.K. Sharma, learned advocate. For the petitioner assures this court that copy of the complete brief shall be handed over to him. Shall be handed over to Mr. Nar during the course of by tomorrow. Let the
official
respondents be filed positively by the next day.
Official respondent has also not.
Yeah, but not filed. You know,
17th July. Item 27.
May I please, your lordships?
Yes. Yes.
My lord, I just want to hand over a short compilation because there have been many affidavits that have been filed. So for your lordship's convenience, my lord, may I just hand over this compilation just to refer to the relevant documents, my lord?
Give a copy to learned advocate general.
Yes. My lord, may I just point out few provisions from the statute?
May I just interrupt, Lordship?
Yes.
If Lordship is taking up this matter for final disposal, then it will take a long hearing.
It's in a date for final.
Yes.
I'll take, my lord, about 20 minutes, my lord, that's all.
I will fix a date on some Tuesday or after the new holiday.
Sir, may I request if it can be, my lord, 27th or 28th of April, my lord?
Indicate to us any date in last of May.
Twenty 26th of May, Lord.
All right, Mr. Mr. Fuken, 26th of May.
26th, my lord. Obliged, my lord, deeply obliged.
Yeah.
My lord, because there's no point keeping the matter pending, because if your lordships can, I think, give some directions, because we are only concerned with two components of the project. One is the southwest and other is southeast, my lord. That is where some directions are called for. Other than that, my lord.
In fact, we have completed except one project, which the date is first phase over. The second phase, it will be over by 2029.
You also file an updated report.
No, we have given everything, Lordship. Yeah, a further update also I can give.
No. If you have given everything further updated report.
Because they have diverted the case from the water project to the anomalies which was found out by CAG in 2022. They brought all those documents and they have said that there are a lot of anomalies and final recommendations of no, those were routine queries and which were made, and there is no such findings that there was financial anomaly at all.
Come up for consideration for final determination on 26th of May.
Deeply obliged, Lord.
Obliged, deeply obliged.